Hi viewers, when a person enters a nation, resides in a nation, or if he is a citizen of that particular nation, law always assumes that he is aware of the law of that particular country. After committing an act which is illegal, one cannot take the excuse that I did not know the law. Ignorance of law is not an excuse anywhere in the world. This video is an effort to bring the important laws of our country in an easy and understandable way. We have often heard the word self-defense in news and movies. For example, in the Malayalam remake Hindi movie Drishyam, and this was remade in Tamil as Papanasam, we see that a whole family will try to hide a death. What would have happened instead of hiding this death if the family had surrendered themselves to court or police? What would have been the actions that would have followed? I will try to explain this with true incidents that happened in our country. First, Madhu Gupta versus State of Delhi. Madhu Gupta is a woman. She has a 10-year-old daughter and she is living with her husband. Some opinion difference with her husband, she fights and comes out. She starts to live with a guy called Satyendra. She finds Satyendra trying to sexually molest her daughter, and so she fights with him and gets out. Then she lives with a guy called Virendra. One day, this Satyendra is coming to Virendra's house. This is after 3 years, so the daughter is now 13 years old. Satyendra and Virendra, they belong to the same village and they know each other. So Virendra gives permission for Satyendra to stay in their house that day. That night, Madhu Gupta, her 13-year-old daughter, Satyendra, Virendra, all four of them are sleeping in the same room. In middle of the night, Madhu Gupta hears her daughter scream, and when she is seeing Satyendra trying to sexually molest her. So she comes and fights and tries to rescue her daughter. Virendra also comes to the help, and Satyendra and Virendra fight intensely. In this fight, Satyendra dies unfortunately. So in panic, Madhu Gupta, the daughter, and Virendra, they leave the body in a box and they just escape. Police finds them after 1 month and arrests them, and the case is coming to the lower court, which is the Sessions Court. In any criminal case, there will be two sides. One is the prosecution side and the other is the defense side. The prosecution side is the state, the government. The defense side is the side where we are accusing a person of having committed the crime. So in this case, the defense side is saying that they did this act so because they wanted to protect their daughter from rape, and so they are asking section 100 IPC to protect them. The prosecution side says that this is murder and Madhu Gupta be given extra punishment for trying to destroy the evidence. On hearing both sides, the lower court finds Madhu Gupta and Virendra guilty because they are saying there is no sufficient proof for an attempt rape, and so it gives them life imprisonment punishment. Madhu Gupta and Virendra move to Delhi High Court for appeal. Delhi High Court says it is the duty of the prosecution to prove beyond reasonable doubt that the accused has committed the crime. It is sufficient if the defense can just bring a doubt in what the prosecution has said. Also, strict proof is not necessary for attempt rape. It is sufficient to prove that the circumstances existed for an attempt rape to happen. Saying so, Delhi High Court acquitted Madhu Gupta and Virendra. So, section 100 says that anyone can cause the death of the person in order to protect from attempt rape. In this case, Madhu Gupta, the mother, she caused the death of the deceased. There is one more true incident. Yeshwantha Rao versus State of Madhya Pradesh. Yeshwantha Rao comes home after a day's work and he goes to the backside of his house to use the bathroom around 10 o'clock in the night. There he sees his daughter with the neighbor guy. So he gets angry and takes a stick to beat the guy. The guy tries to escape and then falls down. A stone hits his chest and he dies. The case goes to court. Yeshwantha Rao pleads that in order to protect his daughter from rape, he had to commit the act, whatever he did. But the prosecution proves that an hour before, this girl had gone to that neighbor guy's house. Hearing this, the lower court gives Yeshwantha Rao 1 year rigorous imprisonment, considering this under grave and sudden provocation. So Yeshwantha Rao moves to High Court, and High Court says whatever time you have served in prison so far is sufficient and releases him, but it does not say him not guilty. But Yeshwantha Rao wanted to prove himself not guilty, and so he went to Supreme Court. In Supreme Court, the defense side, the Yeshwantha Rao side, they proved that the age of the girl is only 15 at the time the incident occurred. So when a 15-year-old girl, even though she gives consent, it is still rape. Saying so, Supreme Court acquitted Yeshwantha Rao and he was freed. So both the cases we saw now, these are ordinary people. So please do not think ordinary people cannot go to Supreme Court or High Court to get acquittal. Madhu Gupta was even a daily wage labourer, and due to this she was not able to get bail and she had to spend some 8 years in prison. Is it possible to get acquittal in lower court itself without going to High Court and Supreme Court? Has anything happened before earlier like this? Yes, there is an example for that. State of Delhi versus Hussain Bano. Hussain Bano, her husband Ashraf Ali, her daughter and son, they are a family and they live in a village. But this Ashraf Ali, he is working in Delhi and he comes and visits his family often. Whenever he comes to visit his family, he rapes his daughter. So this has been happening for 2 years. When the wife Hussain Bano asks Ashraf Ali about this act, he scolds him and beats and breaks her leg. When the situations are like this family, they just go to Delhi one time to visit Ashraf Ali, since he is working there. So that day, what happened? Ashraf Ali was sleeping in the bed, and beneath the bed, his daughter was sleeping. In the hall adjoining that room, Hussain Bano and his son were sleeping. In the middle of the night, Hussain Bano hears her daughter screaming. When she comes and checks, Ashraf Ali pretends to be sleeping and he is just lying on the bed. But Hussain Bano can guess what would have happened. So she starts scolding him for trying to sexually molest her daughter. This Ashraf Ali also gets back and starts fighting, and he gets near his daughter. In order to prevent him from getting near the daughter, Hussain Bano puts her shawl, the dupatta, around his neck and tries to protect her daughter. In this, the dupatta strangulates his neck and he dies. The case then goes to the court. Hussain Bano side, the defense side, they ask for self-defense section 100 protection. But the prosecution states, section 102 says that there should be continuity of danger for section 100 to apply. Here, when Ashraf Ali acted like sleeping, that danger continuity was over. Second, section 99 says that whenever there is time to seek the protection of public authorities, that should be done first. In this case, they had 2 years time to seek the protection, but they did not do. Thirdly, section 99 also states that the extent of the private defense has to be exercised only to the limit of the purpose of the defense. So this was the argument of the prosecution side. So Hussain Bano side asked, even though you don't consider this as self-defense, at least please consider it under grave and sudden provocation and give punishment accordingly. For this, prosecution asked that, how will a person get anger suddenly for something that has been happening for over 2 years? Hearing both side arguments, the lower court concluded that since Hussain Bano's leg was broken by the deceased already, both Hussain Bano and her daughter were living in the fear of when a rape would happen. So the continuity of danger as said by section 102 is present, and hence section 100 self-defense would apply. Saying so, the court acquitted Hussain Bano. So in all the cases we have seen so far, the death was caused by either the mother or father and not the victim. As section 100 has said, anyone can cause the death. So I just like to brief all the sections which we have seen so far. First, section 100, anyone can cause the death of the person who is trying to do a rape. Second, section 102, It says that there should be continuity of danger for section 100 self-defense to apply. We cannot go and kill a person today who committed a rape yesterday and then go ask for self-defense. There is no continuity of danger there. Third, section 99 states that we should go and seek the protection of public authorities first. Section 99 also states that the extent of self-defense to be used only up to the limit of the defense purpose. These are the sections we saw with the incidents which I had said so far. Now we'll come back to the Drishyam movie example which we took. In this movie, whatever that girl did can be pleaded under section 100 self-defense. Even though the mobile phone which contained the evidence was broken, one question is sufficient for section 100 to apply here. The question is, why would that guy come to this girl's house at that night time? So this is enough to protect the girl with section 100. If you like our videos, please subscribe to our channel, share and comment. If you would like to know any other section, please put it in our comment section. Thank you.